he is present and he's in custody. Mr. Pulse. No, Mr. Parks. Here on last time. I know there's a couple of motions on that the state filed that you haven't had a chance to respond to.
So I was going to ask for a couple things. First, we didn't finish the argument on the writ, Your Honor, for the reply. I'd like to do that today. I'd ask for additional time to respond to the state's motions that were filed earlier this month that are outstanding. And then we have a trial date that was vacated. I've spoken with my client. He doesn't want to reset the trial date right now until after he gets the decision from the writ, Your Honor. And then once that happens, we can come back and reset the trial date at that time. It's his druthers, correct?
Yes.
Okay.
You want to proceed with the writ argument, right?
I could, Your Honor. Your Honor, I'll try and be as brief as possible because we argued this out and we spent, close to 40 minutes the last time arguing this. But the last punctilio that we ended on was really the wrong witness came in to testify, and we were talking about the NIBIN classification, NIBIN potato classifications. And Your Honor, what happened is we had an expert that testified for the state. Chap's name was Roy Wilcox. And he was a firearms forensic expert. He's worked for Metro for a number of years, worked for Arizona before that. He is qualified to do the microscopic analyses that are necessary to actually testify at trial as to whether or not a given firearm matches up with a given set of cartridge cases. But that's not what happened here. What happened here is he took the NIBIN entries that were put in Los Angeles by another expert, and the NIBIN comparison that was done to the shell casings that were done by the Metro's own expert, and he took those two documents and said, based upon my view of those two documents, I believe that the firearm is associated with these shell casings. Now, leaving aside, Your Honor, that it wasn't testimony that said, I believe that this gun fired these shell casings, because, again, he was operating off the NIBIN analysis. What you're left with there, Your Honor, is sort of the penultimate problem. I make a timely objection before Mr. Wilcox finishes his testimony saying, I know exactly where he's going to go. He's going to say there's an association here. But in doing so, he's relying on these outside facts. And the state says, no, not so. Just so, but under NRS 50.258, he's allowed to work in these other facts to his analysis that anyone would rely on in rendering their opinion. And more than that, the state went further in the argument, and it said, and we also are going to establish that he independently verified the association himself and will testify associated with that. So this court overrules the objection. And then when we get down to the testimony, what we get is exactly what I think. This is an association based upon the NIBIN that came from these other experts, one of which is not present, works for Metro. The other one is doesn't even work for Metro, is out of state. Neither of which are present. And the reports themselves aren't entered into evidence, but the conclusions based upon them are, and that's how we get from point A to point B. I reiterate my objection at this point, saying this isn't a learned treatise. This is an opinion. This isn't something that people who are doing firearms analysis generally rely on when they're coming to an opinion. This is a fact-specific comparison that's been made. And moreover, Your Honor, the NIBIN entries are telling. The reports themselves, the one from Metro, says a preliminary screening of the images of these cartridges has been performed, but this association has not been confirmed. Confirmation requires a microscopic comparison of the actual cartridge cases. If a comparison and confirmation of the association are needed, please submit to the forensic laboratory examination request through Property Connect. There's a similar admonition for the NIBIN hit that comes out of Los Angeles. But more than that, Your Honor, I don't even need to get into that, because when I get to the cross-examination of Mr. Wilcox, it's very short. I mean, Wilcox's testimony starts on, I think, 122. I might be wrong about that, Your Honor. Let's see here, because there was a long objection that was made there. He starts testifying on 116, Your Honor. Most of that is objection. And when he gets to 124, I ask him just a series of questions. These NIBIN analyses, in fact, it says it cannot be relied on for conclusive proof at trial, correct? Absolutely, correct. He agrees. That these images, that the NIBIN associations that you're testifying based upon, that you didn't put these in, And so your opinion is solely based on the images that were created by someone else. That's his testimony. And I asked him in the images that are said that they cannot be used for conclusive purposes at trial. Correct. And so the problem that you have here, Your Honor, is the state takes a position, the NRS 50-285 overrides everything else and says, doesn't matter if it's hearsay, he gets to base his opinion on that and then bring his opinion into the court as if it is a fact that he arrived at himself. The analogy that I've been using with staff is if we had a report that was written by someone that said the moon was made of blue cheese. This expert looked at that report, and he's a charcuterie expert, and he comes to the court and says, I have looked at the reports for Stilton cheese, and I have looked at the report from the moon is made of blue cheese, and I have determined, based upon looking at these two reports, that in fact the moon is made of Stilton blue cheese. It's not factual. It's not accurate. And Your Honor, it's not countenanced by the statute. The state does not make the distinction for the court, because the court slips into this themselves, that the state's position is that if they can rely on this at trial, the state's position becomes, even if they can't rely on it at trial, they can intrinsically somehow rely on it for a preliminary hearing, because why? That's the hanging participle here. And because there is no answer to that. Grace clearly tells us, and I don't mean grace from God, I mean grace the case, tells us clearly that the justice courts operate under the same evidentiary standards as a district court does for trial. There are some things that are carved out for that, none of which apply here, right? We're not talking about a sentencing. We're not talking about a bail hearing. We're not talking about anything that's actually carved out in NRS 47.020. Everything here has to comport to it being introduced in trial. And it doesn't. The expert agrees these facts could not be adduced at trial, would not be sufficient conclusive proof to base his opinion on at trial. Now, Your Honor, this is also not a smoke and mirrors situation. We are actually, there's a case up at the Supreme Court right now, Smith v. Arizona, where they're having an argument that's even more attenuated than this right now. They granted argument on this January 9th, Your Honor. I can give you the citation of that case. I should probably give you that before I forget and move on. But essentially, Smith v. Arizona, Your Honor, appears to be docket number 22-899. It's been granted for argument. What happened in Smith v. Arizona? Arizona's evidentiary statute, the analog to our 50.285, is even more expansive, which ours is not. Ours does not say what Arizona says. Arizona says that, by the way, if you can't admit the facts or data upon which an expert opinion is based would otherwise be admissible, you can still get it in. The proponents of the data may disclose them to the jury only if their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. Give the state what it wants. Now, regardless of the fact that California doesn't operate this way, regardless of the fact that our statute doesn't operate this way, the state convinced our justice of the peace to accept this attenuated opinion, non-testifying, substitute expert testimony. But in the Smith case, what happened is the state had legally cognizable evidence that was admissible from an expert report in their case in chief regarding, I think it was drug testing in this particular case. But they didn't bring in the witness. They didn't bring in the witness because, so far as we can tell from the record, and there's not a whole lot about this expert was no longer working for the Arizona Police Department at that time when he did the testing. So Arizona, using this law, which is more expansive than Nevada's, comes before the court and says, here, we're going to give you a substitute expert whose opinion is going to be based upon this other expert's testimony, which, by the way, if we had the expert for that testimony, would be absolutely independently admissible. All the parties agree that the report from, I believe the chap's name is Rast in this case, would be 100% admissible. But the secondary report, the substitute expert report, the Longani in this case, on which it's based, that's where this is coming from, Your Honor. And so in this case, we don't even have that. Because unlike the Smith case, where that report would be absolutely admissible standing on its own with the expert testimony, we know two things. We know the Nyman reports upon which the facts are predicated here to get to this expert's opinion say specifically you can't do that. Moreover, it's not a fact in dispute. The state's own expert admits, no, I couldn't base my testimony upon these at trial as conclusive. So there's no disagreement there. We are 2 steps removed from what's currently being argued at the U.S. Supreme Court as a federal constitutional floor that even if the state wanted to allow it, which they don't in the state of Nevada, could they even do that under the federal Constitution? Coupled with the fact, Your Honor, adding injury to insult, Wilcox is the person who could and should have done the microscopic analysis for the cartridges. He just didn't. The state brought him in for the Nyman analysis. So that concludes, Your Honor, for my part, the rejoinder here on the writ. But that is a specific case. I didn't want to re-argue this completely again, but that's just a glaring situation. I objected before he testified. I objected after he's done testifying. I establish exactly what I told the court I was going to establish, and yet it's still brought in. What's more than that, if you look at the preliminary hearing transcript, the court actually has the temerity to say, Mr. Wilcox can't be called to actually do testing here. He doesn't go out in his laboratory and do this testing. That's not what he does. When Mr. Wilcox, when he's identifying what he does, he says, I do microscopic analysis of the cartridge cases in my lab. That's my job description. So, Your Honor, that shouldn't have come in. It established a factual nexus. It never should have been made, Your Honor. And the court, what's more than that, the state might have been able to do that with this expert, but they just simply didn't. And it's not because it's a matter of timing. This case took 2 years to come to fruition. It's not that they lacked investigative time, that it was rushed. They just decided that they weren't going to bring it in front of the court. So, Your Honor, on that, I'll rest. As I said, my client would ask that we reset the trial date after you've given, after you've given a decision here.
Judge, we addressed exactly everything Mr. Claus has raised in our written response and argument last time, both as to why we don't believe this is an appropriate issue, and even if we did consider the merits of it, it was thoroughly litigated in justice court. It was properly admitted. We all know what experts can rely on in submitting their testimony and their conclusions at court. So we see no legal issues with it, on top of the fact that we believe it's inappropriately raised in the writ. We'd submit on that unless the court has any questions.
Just finally, Your Honor, I specifically did not address the quantum of evidence issue here. The association, for instance, where the expert testifies that there's an association between those cartridges, maybe the court could somehow say that that's sufficient for the probable cause standard of a preliminary hearing. But the issue is here, Your Honor. The expert themselves said this is not evidence that they could rely on for their testimony at trial under NRS 50.258. Therefore, this is a situation, Your Honor, where we're not arguing about whether or not the court abused its discretion. We're arguing whether or not the court made the correct legal ruling. And as I said, this issue's up in front of the Supreme Court, only 2 steps removed from what we have here. Even more on firmer ground.
This time the court's going to deny the petition, state carry the order, and we can reset for trial. How soon can you be ready? Set it as soon as you want.
What's your ordinary course setting, Your Honor?
Pretty fast.
Pretty much right outside the 60 days.
Probably going to be March.
August for homestead, it'll be April 15th.
Okay, April 15th, that's a little bit further out.
Maybe April 8th?
Yep, absolutely.
That's great, Judge.
Okay. Pre-trial conference is going to be March 19th, 8:30 a.m. Calendar call, April 2nd, 8:30 a.m. Jury trial, April 8th, 10:30 a.m. And the motions, we can do February 7th, if that's in 2 weeks.
That should be sufficient, Your Honor.
Continued motions are going to be February 7th at 8:30,
The only issue with the 2-week setting is
February
I know
7th,
he's
February
at,
6th?
or, I'm sorry, what?
February 7th or February 6th?
February 7th.
Okay.
he's in NDOC. I'll file a transport order today, but I don't know.
NDOC might bill to us today if we don't need a transporter, sometimes they'll just bring it back.
Officer,
Okay.
we need another transport order for him to come back on February 7th?
We can bring it back.
Okay, is that enough time?
That'll be enough time.
Okay.
Do we need to file an order, or is it okay?
Do you
It's
want
just
a new
standard.
order?
You should be able to use the old.
Okay.
All right.
February 7th at 8:30.
Thank you.
Thank you, Your Honor.
Can you call page 10, please?
Have a seat. Have a seat.
State versus Devils,